thank you, sir and ma'am, for joining us today and heartily welcome you to TNE. I also would like to welcome Mr. Pavel Kalashnikov, representative of the Ministry of Interior, Counselor of the Embassy of Russia in India, a former investigator and lawyer. Sir has shown keen interest in our team and supported us all the way by joining us here today amidst observing necessary protocols and norms. We thank you, sir, for your questions. I would like to extend a warm welcome to Honorable Chairman, sir, Mr. Vipin Sani, Honorable Chairperson, ma'am, Mrs. Kiran Sani, Honorable Vice Chairman, Mr. Aman Sani, and Ma'am Nishtha Sani to the event. I also welcome our Director General and former Judge Allahabad High Court, Honorable Mr. Justice Bhavar Singh, sir, to this event. Thank you, sir, for your presence and for your blessings throughout the event. I further welcome Director DME, Professor Dr. Ravikant Swami, and Additional Director DME, Professor Dr. Rashmi Khurana Nagpal, and all the other heads and deans of Media and Management School present here today. Lastly, I welcome all the participants and the esteemed audience, and I'm very sure that the next 2 days of deliberations and discussions would be an enriching and insightful experience for us all here. To begin with this ceremony, we know that light symbolizes knowledge. It not only dispels darkness, but illuminates our soul. To make this day a blessed one, let's invoke Goddess Saraswati by blessings, by lighting the lamp of knowledge and wisdom. I request all the dignitaries to kindly light the lamp. Our true welcome is never complete without warm words and warmer gestures. It is an honor for us to have our guests here. I request our Honorable Chairman, Mr. Vipin Sani, sir, to welcome Professor Dr. Paramjit Jaswal, sir, with a planter as a token of our appreciation. I request Honorable Chairperson, ma'am, Mrs. Kiran Sani, to welcome Professor Dr. Nishtha Jaswal, ma'am, with the plant. I would like to acquaint the audience with our guest, Mr. Kalashnikov. He is an alumnus of the Kaliningrad State University, Russia, and has worked closely with the Ministry of Interior of Russia on various positions. He has advised the Ministry of Interior, OSCE, Center on Organized Crime in Bishkek, with missions to Kyrgyz Republic and Skopje. He headed the police wing of the police matter activities of the OSSC Center in Bishkek and was the police advisor of the Community Security Initiative in project in Kyrgyzstan. He has served in the Russian military and is currently posted as the Counselor of the Embassy of the Russian Federation in India. We hereby acknowledge your gracious presence, sir, and thank you for joining us here. I invite Honorable Mr. Justice Bhagat Singh, sir, to kindly welcome Mr. Kailash Murthy to the panel. Thank you, sir. This symposium has been an outcome of diligent efforts of the Law School of DV Noida. We have been able to collaborate with different centers of criminology, victimology, and policing of different universities, including the University of East London, the National Law Universities of Shimla and Tamil Nadu, and also with the Indian Society of Criminology and Bureau of Jail Management and Penology, Government of Philippines. We have panelists joining us virtually from Canada, Malaysia, Philippines, Germany, and Brazil, who are actively working in the field of restorative justice and penology. We have had an overwhelming response of participants for the symposium, with over 170 papers received and about 300 participants actively participating, both virtually and here on campus today. We have had the honor of receiving good wishes messages from the Honorable Home Minister, Mr. Amit Shah, the Chief Minister of Delhi, Mr. Arvind Kejriwal, the Honorable Governor of UP, Srimati Anandiben Patel, the Ambassador of Sudan, and many others for the symposium. We intend for the proceeds of the symposium to be published as a dedicated journal listed in UGC Care. I'm sure that the next 2 days shall be enriching for us all participants and audience here as we deliberate upon the theme and create productive and meaningful outcomes and takeaways from it. We would like to share a brief video montage of the law school and the symposium with our participants here today. I request our IT team to kindly play the video montage for us. Moving forward, we are honored by the presence of Nishtha Jaspal here with us today. She is the first woman Vice Chancellor of HPNLU Shimla. A veteran academician, ma'am has a teaching experience of over 35 years. She has written over 6 books and authored more than 60 papers of national and international journals of repute. Her book on environmental law has been cited thrice by the Supreme Court of India in the 2005 landmark judgment of in-rain noise pollution by the then Chief Justice, Justice R.C. Lahoti. She was also invited as a visiting professor by the British Academy London in 1992. I invite ma'am to deliver her keynote address.
Honorable Mr. Justice Bhagat Singh, Mr. Babur, Mr. Karamjit Daswal, the Sani, Mrs. Sani, young Sani, Mr. Ravika, Dr. Ashmi Nagpal, healthy members, guests, beautiful daughters, and handsome sons. Good morning to all of you. I must congratulate at the very outset this esteemed university for organizing this conference on a very, very important topic, that is remaking criminology. I can share with all of you that criminology is not my subject at all. But because we have a hold on us by our eldest daughter, Dr. Rashmi Nagpal, so I am here standing in front of you and talking about the topic. Criminology is a very, very important field. In what context that I'm going to talk about? But before that, I'll just cite a relevant Sanskrit shloka from Srimad Bhagavad Gita. And then you will realize why changes. Yada yada dharmasya glanirбхавти bharat abhyuthanam dharmasya tada atmanam srijami aham. Shri Krishna, he said this, now it means, I'll translate. Whenever there is privation of dharma, then I come. When iniquity increases, then I manifest as incarnation. If I just start with a presumption that human beings are born good, even when I refer to certain theories or approaches to personality and talking about humanistic approach, the presumption is man is born good. And then if I proceed further, after the inception of life on this earth, ultimately human beings realize that they need some norms for their safety, their survival, for the protection of life, liberty, property. Students of law can immediately think about social contract theory. That is, why we surrendered to some kind of rule? Because we needed this protection. The opinions, the perceptions of the jurist, Rousseau, Locke, Hobbes may be different. But when we talk about having some law and order so that everybody can survive to the best of facilities and best of opportunities to grow, to prosper. In every age, we do talk about the circumstances of prevalent. In the present times, I'm just going to refer to a small piece by James Baxter. When there's a state of confusion, self-doubt, and ambivalence, so hard to focus the ball of the humankind on our terrible mother, that shown Medusa, sitting on her pillar of skulls, suicides, abortions, gas splashes, blood-stained mattresses, ton of empty filled bottles, and whatever else the wind may blow in the doorway, including one may fall. The tired dove of the human spirit, flicked again and again in the skyway by the mechanical hawk. So hard for us to praise century of Kali, since a poem has to celebrate its momentum of origin, and yet I'm only able to smile a little and say, not yet, mother. You must wait till I have got the right kind of comrade to turn the top of my skull into a drinking cup. Then begin. Things have to be done in the right order. And if I now take you back 2 centuries back, 200 years ago, when Saint Simon, he declared, I quote, the golden age of the human race is not behind us, but before us. It lies in the perfection of the social order. Our ancestors never saw it. Our children will one day arrive there for us to clear the way. Clear the way. Clear the way. Everybody in the society wants to live in peace, including me, you, everybody. But when the devil in me overshines, I think, what if I fulfill my interest for the others? I'm not the only one. There are so many. What will happen? Conflict of interest, conflict in the society, and in the modern times, this conflict is not going to stay at one place. So today we may be talking globally about globalization, but I must tell you, I always carry the treasure of Vedas with me. We talked about Vasudhaiva Kutumbakam long back. So whatever impact is there in one location, maybe the smallest location, it is going to have impact throughout the world. Jurisprudentially, throughout the world, we talk about fixing responsibility whenever any wrong is done. How to fix the responsibility? How to make anybody accountable? The simplest possible method which we have adopted throughout the world, that is the method of punishment. Impose penalty, make liable. But we have other options too. Yes, we have commissions, we have the legislative bodies, frame laws, they consider, yes. Like if I talk about criminal law, if penalty is to be imposed for any wrong which is determined as offense under Indian Penal Code, if I refer to India, then we have to see number of things. We talk about intention, we talk about factors, and when penalty is to be imposed and discretion is vested with the judges, prescription between minimum and maximum. So, we have just drawn the square. We don't want to cross the threshold of that square. What happened before the crime was committed? What is the reason? What will happen after the accused is convicted? What will happen to his family? Whether imposing penalty will be sufficient. Maybe psychological satisfaction of the victim, his family, or the society, just a psychological satisfaction. Once the judgment is announced, after that, we are not bothered about who was the victim. And victim is reduced to a report, in the reporter, in the storerooms of the courts, that yes, once this case was decided. We have never bothered what kind of stigma, social stigma, family stigma, what kind of ignorance or just ignoring the victim, what kind of life the victim is living. How many victims? If I just give you the example of rape victims or acid attack victims, how many of them ultimately commit suicides? The consequences are many. That may be number of harms which may result from the consequences of the crime, financial losses, physical injury, fear, trauma, feeling of guilt, and whatnot. If you see from the angle of the convict lying in the prison, and I think most of the students, if they have studied criminal law, they have studied constitutional law, they know well about the prison students. What kind of prison abuses are there? So very important question. In fact, I can just quote one decision of the Supreme Court in 2020, Virendra Kumar versus State of Himachal Pradesh. Supreme Court beautifully remarked that criminal jurisprudence must bring a balance between the rights of the accused and the prosecutor. And I hope all of you remember for centuries together, we did think of the rights of the accused. We have procedural laws amended from time to time, and even our constitution talks about all these. You can think of Article 20, Article 21, Article 22, and I hope you have not forgotten D.K. Basu's decision of 1997. Another important question is when we say that in the criminal justice system, who are the stakeholders? If I ask you, you will just count the hierarchy of force. But as you know, we have to include the offender, the victim, the society, the nation, and who not. Another very important issue pertaining to this is, nowadays in criminology, we do talk about it, that is over-criminalization. The over-criminalization, which means there are too many crimes mentioned in the statute books. Whatever happens, we add it as a crime in the statute books. And we have the example. I'm not criticizing as such, because whenever laws are framed, amendments are made, these are keeping in mind the public interest. Like the recent example, we can talk about the Criminal Law Amendment Act 2030, new laws, because these are required. That's what was happening. But the problem is that why can't we think of the pre-stage and post-stage and talking about the reformation, the restoration, instead of over-criminalization? I can quote one Russian-American novelist and brand, I quote, beautifully it was written, the only power any government has is the power to crack down on criminals. Well, when there aren't enough criminals, what makes them? One declares it to be a crime that it becomes impossible for men to live. We don't know many a times what we are going to do will be a crime. So not just talking from the angle of any criminologist, if I just refer to criminal. And if I just refer to William Monger, he took the crime as a social disease, which is dug deep in the society. And the consequences of this is countless crimes which are being committed and millions of criminals who are condemned every year. The consequences, as I have already talked about, number of harms, number of losses, including economic loss, including loss or delay in the national development. Even though we say that we cannot simply rule out the concept of punishment, I would like to refer to Greenhart. He talked about number of mandatory components for punishment. And from common sense point of view, and any person who is a human being, who has compassion, who has empathy, will say yes, these should be the components of the system. Punishment, if it is to be rewarded, then there must be speedy justice. And yeah, very fortunate, India, the Supreme Court of India has already declared, I think from the late 70s, that right to speedy trial is a fundamental right of Article 21 of the Constitution. Very, very important component of this imposition of penalty is after punishment, the offender must have a fair chance of a fresh start. We give a recently criminal identification bill. This was in question. But here I would just like to share with you one story about Mahatma Buddha. Once hardened criminal was taken as sinner, he went to meet Mahatma Buddha. Mahatma Buddha, at that time he had gone for begging. So he was taken to one of the disciples of Mahatma Buddha, Sariputra, who used to read the past of the persons. When he was taken to him, after reading his mind, Sariputra started trembling like anything. Oh, this man had been a sinner for thousands of lives, and he is not going to get informed. That means this is the presumption. And he said, no, you cannot be initiated as a disciple of Mahatma Buddha. He said, no, but I want to change myself. I want to relive. But he was not allowed. Then he started hitting his head against the rock. He said, I am going to commit suicide. I will not live now. At that moment only, Mahatma Buddha arrived. He asked, what is the problem? Buddha said, Lord, I have read his past. He is hardened sinner. He cannot be reformed. So he cannot become your disciple. I said, no, you don't understand. You have read his past. You should have gone into his future. If any person is determined to change, he can change. And his decision is the decisive. This story is very relevant when we talk about not merely punishing but reforming. Now, for understanding this reform, we have just to refresh our minds to different theories of punishment. All of us know deterrent theory. Deterrent theory where the offender is taken as if he has committed the crime by choice. So this theory talks about disproportionate punishment for any offense. If I talk about retribution theory, then even though this theory is nothing but taking a revenge from the offender, but it talks about the doctrine of proportionality, an eye for an eye. Then we have incapacitation theory, where we say remove the criminal from the society. And this is the theory where we may talk about death penalty. I still remember year 1979, in one of the cases, Justice Krishna, because that was the time there was global discussion going on, should we retain death penalty or should we abolish death penalty? Justice Krishna, please say that at the time, only Parliament can pronounce death on death. Now, this is not within the purview of the judiciary. Now, when a reformist, they talk about the death penalty, they simply say that we should think of reformation and not just removing the crime and not the criminal. But reformative theory also fails, mainly because of the reason. Because it requires community monitoring. It requires community rehabilitation. And both are, I think, we should not say impossible, but very, very difficult task. Because for that purpose, what is required? We have to change our mindset. Are we ready to accept the criminals who want to reform themselves as respectable members of the society? I think if any such person knocks at your door, you will close your door on his face. You will not accept. And this is human nature. We don't forget the wrong which has been done to us, and we don't want to. I must appreciate the judicial approach towards reformation. If I refer to Narottam Singh's case of 1978, where Supreme Court concentrated on this reformist approach in order to lead to social justice. If I refer to Ramamurthy's case of 1997, now this was perhaps the only case where Supreme Court talked about 9 kinds of vices in the prison. And when the focus was on removing those kinds of vices like torture, neglect to health and hygiene, insubstantial food, inadequate clothing, prison deficiency in communication, streamlining of jail visits, management of open air prisons, and most important was the reunion of conjugal threats. It was one of the reasons why these convicts, they were committing crimes even in the prisons. And if I refer to Dr. Rakesh Kaushik versus Superintendent General Jail of 1980, beautifully it was observed that every prisoner is a person, and such person holds the human potential which, if unafforded, makes a robber a Valmiki and a sinner a saint. 1977 in Muhammad Gyasuddin versus State of Andhra Pradesh. Again, focus of the Supreme Court was on recreate the good man out of a condemned prisoner. Rajendra Prasad, 1979. Again, the view of the Supreme Court, the bench was headed by Justice Krishna here against imposition of death penalty. Just taking a pause, because we think of only rapes, murders, and all these. Justice Krishna Iyer went to say, if death penalty is to be imposed, it must be imposed in case of white collar crimes. I hope all of you understand from a point of view of any criminologist that the most heinous crime in the society can be any white collar crime, because ultimately it gives birth to all other kinds of crimes. Why robbery takes place, we never think about it. along with a sociologist and a psychologist and a criminologist, if I find I am holding the highest degree in the education and I am getting as per, because most of the states putting even the teachers on contract, paying them just 15,000 per month, and some uneducated person sitting at the top is doing all kinds of works, all kinds of facilities. The frustration will be there, and this kind of frustration will lead to commission of crime. But the other side of the picture was also depicted by the Supreme Court in a number of cases, like Muscat versus State of Maharashtra, 1978. Supreme Court observed that showing more leniency to offenders based on reformative theory would amount to injustice to the society. A kind of conclusive drawn from a decision of the Supreme Court in 1994, Jacob George versus State of Kerala, where Supreme Court said, now this is the balance. Preferring one theory to other is not the sound policy of punishment. Each theory of punishment should be used independently or combined according to the merits of the case. Now, traveling from reformation, now concentrating on the victim, we started talking about the restorative justice. And all of us are aware about the victim compensation edition of 357A in the procedure code. Now, here, because till date, even though the process has started in many countries in different situations for restorative justice, but one question has already been lingering on, it is not yet settled, whether we define this restorative justice as a process or as an outcome. If you ask me, it has to be a process with a certain outcome. Because if we don't have the outcome of the process, then it becomes redundant. And I can just refer to Howard said. He talked from the angle of restorative justice only. He said, crime is a violation of people and relationships. It creates obligation to make things right. Justice involves the victim, the offender, and the community in a search for solutions which promote repair, reconciliation, and reassurance. Even though I'm not in a position to discuss in detail about this restorative justice here as per the limit of time, but I would just like to mention two certain risks, because the risk assessment of this restorative justice has been done a number of times. Now I would refer to Day and Clean. They talked about certain kinds of accountabilities when we adopt or we practice the restorative justice system, like critical accountability, accountability to people, to citizens. That is very, very important. So we have to keep in mind which cases we can have this concept of restorative justice applied, and then focus on victim also, because this approach has to be victim oriented. Then of course the financial accountability, managerial accountability, legal accountability, I hope you understand, because we need full paraphernalia for this kind of a process. It must have outcome. Legal accountability, that we must follow the law of the land, even when we talk about this restorative justice. And very rightly, Justice Court also long back talked about that justice due to the accused is due to the accuser too, that will be referred to the victim. If I just refer to the Indian Constitution, I have already referred to Article 20, 21, and 22. We can refer to Article 38, which is Directive Principles of State Policy when we talk about social justice. Article 41, when we talk about the right to public assistance, a fundamental piece where we talk about compassion for living creatures and for developing humanism. So ultimately, we have to find answers to everything what we want. We are well aware that there cannot be 100% crime-free society, but at least I must have a feeling that I am safe in the society. Finally, I conclude, I can share with all of you, I am a poet by heart, poem is in Hindi. नकारात्मक है चाहे सकारात्मक है ऊर्जा, नकारात्मक है चाहे सकारात्मक है ऊर्जा, प्रकृति का है दंड जो नहीं की उसकी पूजा, प्रकृति का है दंड जो नहीं की उसकी पूजा, दोनों ही नकारात्मकता और सकारात्मकता दोनों ही मानव के हृदय में बसती हैं, दोनों ही मानव के हृदय में बसती हैं। एक का महंगा है दाम, दूसरी बहुत सस्ती है। असीमित इच्छाएं और बदले की भावना, असीमित इच्छाएं और बदले की भावना होता है जन्म अपराध का, असीमित इच्छाएं और बदले की भावना होता है जन्म अपराध का, निशाने पे मानव है लेने रूप अपराधी का। व्यक्तिगत पीड़ा से उभरती है सामाजिक पीड़ा, व्यक्तिगत पीड़ा से उभरती है सामाजिक पीड़ा, कौन थामे कानून और न्याय के मध्य अदालतों में पीड़ा, कौन थामे कानून और न्याय के मध्य अदालतों में पीड़ा। किसको रोके, अपराध को या अपराधी को, किसको रोके, अपराध को या अपराधी को, किसको थामे, पीड़ित या उसकी व्याधि को। Finally, I pray to God and appeal to everyone. जैसे मानव किया पैदा रब ने, जैसे मानव किया पैदा रब ने, वैसे ही क्यों ना संभाले, जैसे मानव किया पैदा रब ने वैसे ही क्यों ना संभाले। दानव लो रोक और देवता बनाओ समाज के रखवाले। All the stakeholders, this is their duty. दानव लो रोक और देवता बनाओ समाज के रखवाले। सर्वे भवन्तु सुखिनः।
Thank you, ma'am, for such an enlightening address. Commissioner of Police, Ms. Lakshmi Singh ma'am, could not join us due to some urgent assignment. I would like to take this opportunity to welcome the Deputy Commissioner of Police, IPS Harish Chandra sir, to this event. We welcome you, sir. I would request Director DME, Professor Dr. Ravikant Swami sir, to welcome sir with a plant. Thank you, sir. Taking the event forward, we are honored by the presence of Professor Dr. P.S. Jaswal here today, an academician, professor, and presently the Vice Chancellor of SRM University, Haryana. Jaswal sir is the former Vice Chancellor of Rajiv Gandhi National University of Law, Patiala, and the former Chairperson of Department of Laws, Punjab University, Chandigarh. He has been bestowed with many honorary awards, including the most prestigious Nehru Centenary British Fellowship Award by the University of London. Together with Madam Nishtha Jaswal, Vice Chancellor HPNLU, in 2018, they became the first couple to be Vice Chancellors of the National Law Universities at the same time. An established author of environmental law and human rights, Sir has served as the chairman of various academic and administrative bodies, expert committees, advisory boards, and governing councils. I invite Sir to deliver the presiding address and to declare the conference system.
A very good morning to all of you. Honorable Mr. Justice Bhavan Singh Ji, Mr. Vipin Sani, Chairman, Mrs. Sani, Mr. Kaved, Mr. Nishta Jaswal, Ravi Kanji, DCP Harish Chandraji, Amit Sani, and Nishta Sani, and I take the liberty to speak on behalf of my better half, our very beloved student Rashmi Nagpal. I'm not using the word my, otherwise I get the report. So our dear student Rashmi, faculty members and dear students. And indeed in a dilemma, what to speak for many reasons. One, I am not a man with a criminal background, nor I have been teaching or studying the criminal law since the days I passed law in 1970s. But more than that, the dilemma is, which I normally say, that if you want to shake the confidence of the speaker, ask the speaker to speak in the presence of his wife. And if you want to shake the confidence completely, ask the speaker to speak after your wife has spoken. I stand here before you in both the situations, in the presence of my wife and after my wife has spoken. And added to this, there was another vote that we are, all of our present academic assignments are staying in two different stations. We could not exchange with each other what she is going to speak and the rest I should speak. So what I thought I would speak, she has already come. Be that as it may, I'll discharge my duty because our teacher said that when you become a professor, you cannot say that I do not know any field of law. So you have to speak. I believe and believe it firmly that we all want one thing which is common in each one of us who is in this hall. That is peace. For having a peace, one must get justice. Nothing rankles more in the human mind than the sense of injustice. What is justice? When you get whatever is due to you, you say, I got justice. I'm reminded of Professor Dicey, who was basically a historian and who gave the concept of rule of law in 1885. One of the three formulations of Professor Dicey stated, equality before the law and equal subjection of all the people to the ordinary course of the land without any distinction on any basis. The rule of law runs like a golden thread to the entire Constitution of India. And Professor Nishta Jaswal has already referred to some of the provisions, including fundamental rights, director principle, and fundamental duties also. If I look at the program which has been tabled before us, I'm supposed to give a presidential remarks, but with the permission of the chair, I'm a little dramatic also, because then I will be told that I'm speaking on what my wife has spoken. Talking about the rule of law, and what Professor Nishta said, that when we are born in this world, in whichever nation, whichever part of the world we are born, irrespective of that, we are all equal. None of us is a criminal. But during our lifetime, we do commit, a number of us, we commit some offenses, some of which are called criminal offenses, and we are punished accordingly. I had a look at the topic of this seminar, remaking criminology, contemporary rights from the criminal justice system. I found it the topic is left open. We are not talking about the criminal justice system in India. It is we are talking in general in the society, to whatever nation we may belong. Now, what is this criminology? Criminology, if you dissect the anatomy of the word criminology, it includes crime or the study of crime, criminal offense, about the criminal, and it also encompasses what Professor Mishra Jaswal elaborated in the end of our lecture, the society and the circumstances in which the crime is committed. There may be a mother whose children are hungry and they have not taken a loaf of bread for the last 4 or 5 days. They are on the verge of dying. If she steals the bread from a shop, does she become a criminal to save the 4 lives of her children? I do not go in detail to this question. You can ponder upon under what circumstances, under what behavior, in which society a crime is committed. That becomes very relevant. But when we proceed further with the topic, that when we are talking about remaking of criminology, so we know about, I talk in the Indian context, we know about different types of crimes which are defined under the Indian Penal Code. We know about the Criminal Procedure Code by which the criminal trial is to be conducted. And we know about the Evidence Act by which the crime is to be proved beyond a reasonable doubt to punish the person. But when we, after the colon, when we read the topic, contemporary insights from the criminal justice system. So we have to correlate the remaking of a criminology. Whatever we understand from the word criminology, we have to correlate it the rest of the part of the topic in contemporary insight from the criminal justice system, contemporary things today around us. Gone are the days when a criminal lawyer, pardon me, sir, you have been the honorable judge on the bench, but I'm taking my liberty to say, gone are the days when a criminal lawyer was supposed to know only 3 laws: Indian Penal Code, Criminal Procedure Code, and Evidence Act. And if he has mastered 3 laws, he was known as a known criminal lawyer. Today, no criminal lawyer can call himself well versed with the criminal law only on the knowledge of 3 subjects, that is the Indian Penal Code, Criminal Procedure Code, or evidence. When we talk about the criminology, how it developed, various theories have been referred by Professor Mishra Jaswal, like deterrent theory, retributive theory, incapacitation theory, and reformative theory, and so on. They were the part of the development of the criminology, which developed as one of the independent subjects, and she did refer to one of the very famous author of criminology, Sutherland. And what I repeat at the cost of repetition what she said, rather what Sutherland said, and she quoted that the criminal behavior is not born with the person in the society. Criminal behavior is learned in the society. Nobody is born as a criminal. Then, while punishing him, we have to take into consideration different parameters. There have been different times when different theories were supported by various tourists, various judges, including India. Now, why that change? That change is because of the environment in which that particular jurist or judge, he was born and he was educated and he lived in that particular society. Now, coming to the contemporary insights, we see that a number of changes have taken place in the contemporary times. I start from the very basic thing. A couple of years back, the whole world saw the effect of a microbe, and we were in COVID-19 pandemic lockdown situation. I started my lecture today by saying that justice is most important. If justice delayed, justice denied. But the courts rose to the occasion. In a criminal trial, also they started hearing the cases virtually. Virtual courts continue to function so that the person gets justice at the early age. So we find that justice delivery system, which is an integral component of the criminology of criminal justice system, that saw a change, that it is not necessary to have examination or the criminal trial only in the presence of the judges in the court physically. It can take place even virtually. In 2021, there have been some amendments in the criminal law which have been accepted by the parliament. The parliament has made the law where the magistrate has been given the power even to attach the property. Today, the method and the procedure followed to prove the guilt of a criminal is also changed in the contemporary days. For example, DNA profile is used for various crimes, for reaching to the conclusion of the crime. We also use artificial intelligence, which is the upcoming. In fact, in America, a case took place where the judges, to fix the guilt of a criminal, used the artificial intelligence and ultimately convicted the man. The appeal was filed that you can't mechanically declare somebody as a criminal. The judgment has to be on the basis of application of law by the jury or by the honorable judges. Then the case study was done that had that artificial intelligence not been used, what would have been the result of the trial? And you may be surprised to know the result was the same. The judges, without the use of artificial intelligence, would have the better of having the better. Today, artificial intelligence is also used to identify the crime or the criminal, or even to detect the criminal. Nowadays, various other species of crime are coming up, As we say, the law is not static, law is living. So as the law grows, the new species of crime are also growing. One of them I can refer to the young student which they are studying, which of course was not there when we were the student, but we continue to be student as teacher also. So therefore we say, yes, it is relevant to us, cybercrime. We had neither the internet technology or nor the computer nor the smartphone when we were studying in the classrooms. But now cybercrime, that has become a new species. So the theories of criminology have to be changed accordingly. Another very important factor, we have seen the, not seen, but we have definitely heard. The First World War, the Second World War, we are seeing even the present ongoing war also between the two nations. But within the nation, those who are not involved in actual war, we are seeing another kind of a war, that is the terrorism. Again, the offense committed by the people who are called a terrorist. What is the definition of terrorist? Who becomes the terrorist? Why he becomes the terrorist? They are all related to the development of criminology. And when we talk about the remaking of criminology, we have to take into consideration these aspects. Then, with the development of this ICT, the whole world has shrunken into a small village. Now the geographical boundaries, they have almost diminished when it comes to commission of a crime. And what I call in the legal terminology, transnational crimes. That when we talk about the criminology, we have to consider even that aspect of the crime which is committed across the boundary, the geographical boundaries. Coming back to the keynote address of Professor Nishta Daswal, one of the fundamental factors which we find in making a person as a criminal or forcing him to commit a crime, even if he was not a criminal, he was a very ordinary person. And the study of the different cases in which a heinous crime was committed, we have found that there are many examples where the actually person was not with a criminal background, but circumstances forced him to commit that crime. And that is to be studied when we are talking about remaking of a technology. And that is the social inequality. I started with the rule of law of Dicey of 1885, which talked about equality before law and equal subjection of all the people before the same ordinary courts. But that equality has to be a substantial equality, taking into consideration the social and economic factors which affect the behavior of the human beings. Today, globalization, liberalization, this has affected the human behavior so much. And with this new consumerism, I have a smartphone, whether I can afford or not, my children wants to have a better model of this. If I can afford, I will provide them, otherwise my children may adopt a method which is not expected of them. The new consumerism. Even if I try to control my children and my family, know that you should not go after the costly things, the costly gadget, this and that. The peer pressure. In the classroom, who doesn't have a smartphone? Who doesn't have a phone which doesn't support 5G in India? I mean, that also affects and forces you to change your course of action. What I wish to convey to you is that when we think of remaking of criminology, we have to take into consideration the growing crimes and the factors which are affecting or which are responsible for the growth of the criminal behavior of the individuals in the society. Then only we can talk about this growth. Professor Nishta Deswal did refer to Rakesh Kaushik case. A wonderful observation by our judiciary. Whether you love it or not, whether you like it or not, but we must accept the fact that in India, the contribution of our judiciary has been tremendous as far as the growth of law and legal concepts are concerned. And we are proud of our judiciary. The observation of Rakesh Kaushik case were, every person is a person. No person is born as a criminal, which I earlier also mentioned. Therefore, the last theory to which Professor Nishta Deswal referred to, the reformative theory, which talks about your rehabilitation also, which talks about your restorative justice. Restorative justice was not recognized in earlier time, 40 years back, as much as it is recognized today. Today, you go to the foreign jurisdiction of the Western countries in particular, the restorative justice is the norm. I committed a crime, suppose I become a criminal, I am convicted. What happens to my family who are not the instigator or conspirator or partner in the commission of the crime? What wrong my wife has done or my children have done, if I am independently committing a crime and they can't earn their livelihood also? The Law Commission of India, a couple of years back, recommended that even in India, the death sentence should be abolished except in the terrorist crimes. We have become a party of International Covenant on Civil and Political Rights, but we did not ratify Optional Protocol 2, which talks about abolition of death sentence. And we know how many countries have already abolished the death sentence. But there is a change. There is a change from the judiciary. The judiciary said in a number of cases that death sentence should not be as a matter of rule. It should be only as an exception. Rarest of rare cases, right from Bachan Singh onward, Mr. Bhagwati and Justice Krishna here to begin with, they started with the theory of rarest of rare cases. Not only that, recognizing the personal dignity of the human being to live in the human dignity. They said if a person has been awarded with a death sentence and he is not executed the sentence within a specified period, it should be converted into life imprisonment. Going further, the mandatory death sentence 303 of the Penal Code, where there was no alternative of a life imprisonment, was declared unconstitutional. We are living in a nation, we can hold our head high because of the fundamental law of the land, the Constitution of India focuses on the dignity of the individual or the right to live with dignity in this country. So, when we are talking about the remaking of the criminology, we have to take 2 or 3 most important points into consideration. One, I summarize, we should not talk about only the traditional criminal offences given in the Indian Penal Code. You see, after the Burma Committee, 13 criminal offences have been added in the criminal code itself. Secondly, we should not hate the criminal, we should hate the crime. And when a person has committed a crime and he is labeled as an accused and subsequently as a criminal, we should dissect the anatomy of the circumstances of the society in which he was born, he was developed, if he is educated, then educated, and ultimately the compulsion led him to commit that crime. Of course, punishment has to be given to the person who is guilty. But I am a strong supporter of reformative theory, rehabilitative theory, and in particular, the restorative theory of justice. With these words, I would like to convey my thanks to you all that you heard me so patiently. Thank you very much.
Thank you, sir, for your time. Now, we have Mr. Harish Chandra, IPS, and Deputy Commissioner of Police here with us today. An IPS of 2010 batch of the Uttar Pradesh cadre. His alma mater is Delhi University. Previously, he was posted as ASP of Kanpur and Muradabad, and then as SP at Mahoba, Auria, and Kannauj. He is presently posted as DCP of Noida since 2020. I invite sir to address the cadre.
Honorable Justice Overseas, Honorable Judge Jaswal sir, Madam Jaswal, all distinguished dignitaries, and my dear young friends. Because of urgency and some VIP engagements, CP ma'am wants to come here, but due to some issues, she was not. On behalf of CP madam, I am representing her. When you go to a college or a school or in a school, it's very difficult to find yourself कि आपको कहाँ बैठना, इस तरफ बैठना है कि उस तरफ बैठना है। जैसे अभी प्रोफेसर साहब ने कहा कि हर प्रोफेसर भी एक विद्यार्थी होता है, स्टूडेंट होता है। As a student of law, lawyers, legal professionals, जजेस और पुलिस प्रोफेशनल्स में बहुत सिमिलैरिटीज हैं, बहुत समानताएं हैं। एक लंबी जर्नी मैम ने बताई आपको, लोग भी गुजरे जर्नी से, कभी कभी मौका मिलता है तो उसको फिर से रिवाइज करते हैं। एक बहुत फेमस बुक थी द थ्योरी ऑफ जस्टिस, जॉन रॉल्स 1971 में लिखी थी। उसने उस बुक में उन्होंने एक वेल ऑफ इग्नोरेंस की बात की। एक वेल ऑफ इग्नोरेंस होता है, जैसा सर ने बताया कि जब आप सोसाइटी में आते हैं तो एज ए इंडिविजुअल आप सोसाइटी में आते हैं, नॉट एज अ क्रिमिनल। रॉल्स भी उसी बात को कहता है। उसका ये कहना है, तो आप बहुत लोग जानते होंगे, जो मुझे इसलिए अच्छा लगता है या इसलिए समझ में आता है क्योंकि मैं पर्दे के इस तरफ हूँ इस समय, और मैं देख पा रहा हूँ कि कैसे क्राइम होता है, कैसे उस क्राइम की हम प्रोसीडिंग्स करते हैं। बेसिकली हमारा काम जो है वो प्रोसीजर्स को फॉलो करना है, उसके सब्सटेंस की वैलिडिटी को एक्सेप्ट करना, वैलिडेट करना जुडिशरी का काम है, लॉ मेकर्स का काम। पर एज अ एनफोर्समेंट ऑफिसर हमारा काम है हम उस ड्यू प्रोसीजर को फॉलो करें और एस्टेब्लिश करें। रॉल्स इस बात पर फोकस करता है, जब आप बेल ऑफ इग्नोरेंस में जाएंगे तो आप सारी चीजें भूल जाएंगे, आप क्या है क्या नहीं है क्या है, और जब उससे बाहर निकलेंगे तो आप एक एंटिटी होंगे, यू विल बी एन इंडिविजुअल एंटिटी। जैसा सर ने कहा कि आप बॉर्न क्रिमिनल नहीं, हालांकि पहले बॉर्न क्रिमिनल टाइप थी हमारे शेड्यूल्ड, जिसे बाद में एक लॉ ला करके हटाया गया। तो हमारा मकसद ये होना चाहिए, चाहे हम पर्दे के उस तरफ हो चाहे पर्दे के इस तरफ हो, प्री कंसीव नोशन से हम कोई काम ना करें। कि हम अपने लिए नहीं कह रहे, क्योंकि हमारा मैक्सिमम कन्फ्रंटेशन जो होता है वो वकीलों से ही होता है, बट सीखने को भी सबसे ज्यादा उनसे मिलता है। आज के समय में, आज के टाइम में चीजें बहुत तेजी से बदल रही है, गवर्नमेंट भी काफी लॉज को चेंज करने में लगी हुई है, काफी सुझाव मांगे जा रहे हैं। उसका रीजन यही है कि टेक्नोलॉजी ने चीजें इतनी आसान या इतनी मुश्किल बना दी है कि हमें चाहकर या ना चाहे अपने आप को उसके हिसाब से एडजस्ट करना पड़ेगा। आज सुबह के मैं 2 एग्जांपल बताता हूँ। हम लोगों का डेली क्राइम रिव्यू होता है। As an officer, we have to review daily our crime and report to our senior officers, and they have to report higher officers. एक बहुत वेल रिनाउंड फैमिली में एक बच्चा काम कर रहा था, 15-16 साल की उसकी एज है। देखिए फ्लॉ कैसे बनता है, कैसे टूटता है। बच्चे ने घर में चोरी की, 15-16 साल का हुआ, उन्होंने पकड़ के पुलिस को दे दिया, पुलिस ने पकड़ करके जेजे बोर्ड को भेज दिया, जेजे बोर्ड ने मालिक के खिलाफ मुकदमा लिखवा दिया। अब इसमें हमें बताती है एज अ पुलिस ऑफिसर हमारा काम क्या है, जो प्रोसीजर है उसको फॉलो किया। एज अ सोशल एंटरप्रेन्योर, एज अ सोशल एक्टिविस्ट, एज अ सोशल मेंबर ऑफ सोसाइटी, इस पे हमें सोचना चाहिए ये हुआ क्यों। पहली बात तो 15 साल के बच्चे से काम नहीं कराना चाहिए, इट लॉ। दूसरा, इट इज ऑल्सो अगेंस्ट द लॉ, बट चोरी की क्यों। These are some questions, ऐसे बहुत सारे सवाल हैं। अभी मैं आ रहा था, रास्ते में एक जर्नलिस्ट का फोन आया, सीनियर जर्नलिस्ट, तब एक वीडियो कॉल आया था, मैंने उठा लिया, उसमें मेरा वीडियो बना चल रहा। ये पहले नहीं होता, क्योंकि पहले वीडियो कॉल ही नहीं होती, पहले सिर्फ कॉल होती थी और उससे पहले वो भी नहीं होता। तो टेक्नोलॉजी के फायदे और नुकसान दोनों हैं, हम उसे कैसे यूज करते हैं। जैसा आपने कहा सर, फर्स्ट वर्ल्ड वॉर, सेकंड वर्ल्ड वॉर, थर्ड वर्ल्ड वॉर अगर कभी होगी तो मेरे हिसाब से तो वो चल रही है, वो कभी विजुअल वर्ल्ड में आएगी नहीं, वो ऐसे ही चलती रहेगी। इट विल बी द वॉर बिटवीन द माइंड्स, वो फिजिकल प्लेटफॉर्म पे कभी होगी ही नहीं। एक बहुत अच्छे फिलोसफर है माइकल फूकोल्ट, नाम सुना होगा आपको। उनकी एक बहुत अच्छी कॉन्सेप्ट थी कि नॉलेज एंड नॉलेज इज पावर। इंफॉर्मेशन नॉलेज, देन नॉलेज इज पावर। जितनी इंफॉर्मेशन आपके पास है वो कम है। मैं ये बात इसलिए बता रहा हूँ एज अ लीगल प्रैक्टिशनर इन फ्यूचर, एज अ पुलिस ऑफिसर इन प्रेजेंट, हम लोग डेली देखते हैं बहुत सारी चीजें हमें भी नहीं पता होती, हमारे कांस्टेबल को नहीं पता होती, हमारे सब इंस्पेक्टर को नहीं पता होती, स्टेशन हाउस अफसर को नहीं पता होती। अगर वो सोर्स ऑफ इंफॉर्मेशन हम लोग बंद कर देंगे, सुनना समझना बंद कर देंगे, तो ना नॉलेज तक पहुंच पाएंगे, और अगर नॉलेज नहीं होगी तो इफ यू डोंट हैव नॉलेज देन यू आर पावरलेस। ऑनरेबल सुप्रीम कोर्ट हैज नॉलेज, दे आर पावरफुल। वो मेजर्स को करेक्ट करते हैं, जहां गलती करते हैं बताते हैं, जहां जगह जो रास्ता दिखाना दिखाते हैं। मे बी दे आर आल्सो नॉट एब्सोल्यूट, क्योंकि 4 जजेस की जो बात एक खंडपीठ कहती है, 7 जजेस वाले उसको जो है वो चेंज कर देती है। क्यों कर देती है? इसीलिए कर देती है कि वी शुड ऑलवेज इवॉल्व आवरसेल्फ, नथिंग इज एब्सोल्यूट। और आज के वर्ल्ड में जहाँ टेक्नोलॉजी का इतना ज्यादा उपयोग हो रहा है, उतनी ज्यादा हम लोग टेक्नोलॉजी ड्रिवन हो गए। आप सोचिए आपकी सारी चीजें जो है वो कंट्रोल्ड है, आपका फोन कंट्रोल्ड है, आपका लैपटॉप कंट्रोल्ड है, आपके घर के डिवाइसेस कंट्रोल्ड है। आप जाते घर में अलेक्सा ये बजा दो, बजा देती है। इन अ सेंस इट इज वेरी गुड, क्योंकि फैसिलिटेट कर रहा है, पर इन अ सेंस इट इज वेरी डिफिकल्ट आल्सो। जैसा सर ने कहा कि व्हाइट कॉलर क्राइम जो है आज की डेट में सबसे ज्यादा खतरनाक है, सबसे ज्यादा डेंजरस है, डेंजरस टू इकोनॉमी, डेंजरस टू सोसाइटी, डेंजरस टू एवरीवन। क्यों? तो उसके रेमिफिकेशंस बहुत हाई है, बहुत हाई। ऐसे ही आने वाले टाइम में साइबर क्राइम भी उसी तरह का होगा, उसी कैटेगरी का होगा। आपकी जो पर्सनल लाइफ वो पर्सनल ही नहीं रह जाएगी, and that will be a very challengeable issue for everybody, for us, for you, for who are in diaspora, for everybody. Even decision making bodies like in police, in judiciary, everywhere, हमें भी बहुत कुछ नहीं पता है। नई टेक्नोलॉजी के बारे में अगर कोई केस रजिस्टर्ड होता है तो उसको ऑनरेबल जज साहब को भी हमें बताना पड़ता है, उनको भी लीगल एडवाइजर चाहिए, उनको भी साइंटिफिक एडवाइजर चाहिए, क्योंकि वो चीजें पहले नहीं थी जो अब है। मैं ये पॉइंट इसलिए बता रहा हूँ क्योंकि अगर आप ये सोचे कि आपने जो है वो एक यूनिवर्सिटी से, कॉलेज से एक अच्छी डिग्री ले ली तो आपका प्रोफेशन चल जाएगा, तो ऐसा नहीं है। यू हैव टू इवॉल्व योरसेल्फ डे बाय डे, पर डे। अगर आप नहीं करेंगे सर्वाइव करना बहुत मुश्किल। और बाकी मैं आई बिलीव in Gandhian philosophy in the last, as Gandhi ji always says, जब तक सबसे लास्ट अंतिम व्यक्ति का भला हम लोग नहीं कर देते, उसको न्याय नहीं दे देते, तब तक हमारा काम पूरा नहीं होगा। And it is a very long path, very long path. बहुत उम्मीदें हैं आप लोगों से इस सोसाइटी को, हम लोगों से तो है ही नहीं। हम उसमें कितने पास हो रहे हैं, कितने फेल हो रहे हैं, कितने बढ़ पाए हैं, कितने नहीं बढ़ पाए हैं, इट इज इशू ऑफ डिबेट, इट इज इशू ऑफ क्वेश्चन, बट उम्मीदें बहुत। एक व्यक्ति जब एक वकील साहब के पास जाता है, मैं एक स्टोरी सुनाता हूँ छोटी सी। मैं गोरखपुर में पोस्टेड था, तो वहां पर एक सज्जन थे, उनका एक जमीन का डिस्प्यूट चल रहा था। तो वो क्या करते थे, रोज सुबह जो है सत्तू आप समझते हो, सत्तू लिया और कुछ जो है वो भूजा लिया, बांधा, 7 बजे निकलते थे, फिर वकील साहब के पास जाते थे, 5 एप्लीकेशन ड्राफ्ट कराते। एप्लीकेशन के ऊपर कुछ नहीं लिखा होता था, मजमून सेम होता है, तो उसका कंटेंट होता था वो सेम होता था। और ऊपर में फिर जिलाधिकारी महोदय, एसएसपी महोदय, आईजी महोदय, ये महोदय, वो महोदय, और फिर दिन भर वो एक एप्लीकेशन सब जगह देते थे। 6 बजे तक एप्लीकेशन देते थे, फिर 6 बजे से फॉर्म मिलाना शुरू करते थे शाम को। साहब मैंने एप्लीकेशन दी, क्या हुआ? फिर दूसरे को, फिर तीसरे को, फिर चौथे को। तो एक दिन मेरी उनसे बात, उन्होंने बताया साहब मैं ये कई दिनों से कर रहा हूँ। खैर उनकी समस्या का समाधान कराया गया। इसका बताने का मकसद ये है कि आदमी में जीवटता बहुत, अपने काम के लिए वो बहुत दौड़ता है, पर उसको सही प्लेटफॉर्म नहीं मिलता है, सही जगह नहीं मिलती, सही लोग नहीं मिलते, या करने वालों की मंशा नहीं होती है, या वो सही जगह पहुंच नहीं पाता है। तो आप और हम वो माध्यम हो, मीडियम है, जिससे उसको वो न्याय मिलता या मिलेगा। बिफोर इंडिपेंडेंस ओनली lawyers and journalists, these two are the noble professions. And noble क्या, डेडिकेटेड प्रोफेशंस। लोगों ने अपनी प्रॉपर्टीज बेच दी थी वकील बनने के लिए। गांधी जी, नेहरू जी, आप जिसको उठा के देखिए, डॉक्टर अंबेडकर, XYZ। क्यों? क्योंकि उनको पता था कि अगर मैं जानूंगा या मैं जानूंगी तभी मैं बता पाऊंगा या मैं बता पाऊंगा। अगर मैं जानूंगा ही नहीं तो बता क्या पाऊंगा। इसलिए मेरी आपसे बस एक यही सलाह है, रिक्वेस्ट है, एंड फॉर एवरीबॉडी एज ए स्टूडेंट ऑफ लॉ, कि हम लोग अपने जानने की जो जिज्ञासा की जो गतिविधियां है वो बंद ना करें, हमेशा चालू रहे, हमेशा वो कांस्टेंट चलती रहे, तभी ये अच्छे सफल प्रोफेशनल आप बन पाएंगे। चंद्रकांत त्रिपाठी निराला जी का एक लाइन है, बहुत अच्छी लाइन है, जो मैम ने कविता कोट की, तो मैं लाइन वो सिर्फ 2 लाइनों की बात रख के अपनी बात खत्म करूंगा। उन्होंने ये कहा, मैंने मैं शैली अपनाई, मैंने मैं शैली अपनाई, मतलब मैं हूँ, मैं हूँ, मैं हूँ, आई एम द सुवंश, आई एम द सुवंश। देखा एक दुखी निज भाई, झट उमड़ वेदना है। एक दुखी आदमी को देखा, तुरंत अंदर से वो फीलिंग आ गई कि नहीं, इसकी मदद करनी है, ये हमारे जैसे। तो हमारे लिए बस वही बात लागू होती है कि हम कुछ नहीं है, हम वो है जो किसी की मदद के लिए यहाँ बैठे हुए हैं। ऊपर वाले ने एक काम दिया, उसको करना है। तो लॉट्स ऑफ थिंग्स अबाउट डिस्कशंस रिगार्डिंग पुलिस एडमिनिस्ट्रेशन एंड ऑल दैट, वो चलता रहेगा, अनवरत है। कमी है तभी उसको हम सुधार कर पाएंगे, अगर कमी नहीं होगी सुधार भी नहीं कर पाएंगे, आप शुरू हो जाएंगे। मेरी यही आप लोगों से जो है वो गुजारिश है, इस मंच पर बुलाने के लिए बहुत बहुत धन्यवाद। जय हिंद।
Thank you, sir, for your thought-provoking address. Due to paucity of time, sir has to leave for an urgent meeting. So I request our honorable chairman, sir, Mr. Vipin Sani, to felicitate sir with a token of our appreciation.
Let's skip. The whole video. Sir.
Thank you, sir. No institution can run without the presence of a great leader, and we are privileged to have our Director General, Honorable Mr. Justice Bhagat Singh Sir with us. To acquaint the audience with his lordship, Honorable Mr. Justice Bhagat Singh was appointed in UP Judicial Service in April 1970 and promoted to higher judicial services in 1979. His lordship presided over the Special Court of CPI Dehradun from 1983 to 87. Sir was elevated to the Registrar, Allahabad High Court in 1992 for 3 years. Served as the office of Registrar General of Supreme Court of India from 1998 to 1999 and was elevated to a permanent judge of Allahabad High Court in 1999 until he laid his office in 2007. He was appointed as the president of the UP State Consumer Commission. Thereafter, Sir adorned the august office of Chairman, Judicial Training and Research Institute UP from 2012 to 2014. Thereafter, he joined Delhi Metropolitan Education as a professor and director general in 2004. I request his lordship to address the gathering and give us his witness.
Honorable Chairman and Vice Chairman, Mr. Vipin Sahni and Mr. Ahmad Sahni, they are out for a while. They will be joining very soon. Madam Kiran Sahni, who is the architect of Sunshine and Educational Society running these institutions. Dr. Professor Jaswal, along the Vice Chancellor and a friendly person. Dr. Nisha Agarwal, Vice Chancellor of Himachal University, Himachal Pradesh University. Mr. Pave, the Consular in Russian Embassy of a friendly country, Russia. Mr. Nishta Agarwal, Mr. Sahni, Mr. Ravikant, the Director of PME, Dr. Nagpal, Additional Director, PME, faculty members, delegates, and dear students. The judiciary, the police, the lawyerdom, all are in utter confusion in the present times as the commission of crimes is not coming under control. The courts have been awarding death sentence, life imprisonment for commission of heinous crimes, post Nirbhaya hangings. My young friends perhaps may not be knowing that in 2012 there was a gang rape in Delhi. It is popularly called Nirbhaya gang rape case. 4 convicts out of the 6 were awarded death sentence, and a concept, a belief developed in our society that perhaps with these hangings of 4 convicts, the crime will come under control. But no, it proved to be wrong. The rape crimes are increasing day by day. Brutal crimes are being. As a matter of fact, punishment is for the individual and crime is for the society. Friends, Dr. Mr. Agarwal talked about the reformative theory. The first punishment which came into vogue was the deterrent theory. It was a theory which was evolved for the criminals to know that they should feel that the jail life is very painful. Next was for the brutal crimes of murders. But this deterrent theory did not deter the criminals who were hardened. I'm reminded of an anecdote which happened in England. There was a time in early 13th century when the petty crime of theft, particularly pickpocketing, alarmingly increased. People were scared of keeping a phone in their pocket because they knew that they would be pickpocketed. Particularly in crowds, when the king was approached to formulate a very strict punishment for it, he ruled that now onward, death sentence will be awarded to the pickpockets. A sentence which would never be thought of in the present times because we believe today in reformative theory. But that was the demand of the time in those days. And not only the death sentence, but the king also ruled that this death be awarded at the crossroad where people gather to see so that they can have a fear in their minds that criminals who used to assemble and after execution, thousands of people found that they have been pickpocketed. Their purses have been removed. So, deterrent theory did not prove to be very effective, particularly for those who are the hardened criminals. And prompted by this anecdote, a judge in Rajasthan also awarded death sentence in a bread fried burning case to the husband and said that he would be hanged till death by neck on the main crossroad of Jaipur city. The High Court reversed that finding, though death sentence was maintained, but awarding death sentence at a crossroad is considered to be a barbaric method. Friends, then the society moved on to the retributive tit for tat. If a criminal has caused hurt to the eye of another, then the eye of the criminal should be blinded. That was the retributive show. In Saudi Arabia, still, Sat se juda is considered to be the befitting crime for murderers, rapists, and the criminals who had committed heinous crimes. But this 32 was considered to be a wild character of justice, and the philosophers of justice advised the judges and the lawyers, the jurists, that justice should not be revengeful. And this man referred to Justice V.R. Krishna Iyer, who was not in favor of death sentences, because he used to say that God has given life, though he was a communist by belief and did not believe in God, but still he maintained that there is some supernatural power who had given us life, and it is only he who can take it. And he said, in the context of his own having escaped death, which he had seen closely when he was wading through water in a river at the age of just 13. He was in favor of abolition of death sentence, but unless it was abolished, he talked of rarest of rare cases, as mentioned by Mr. Jaswal Saab. But he recommended that for the offenders of heinous crimes, for those who commit murders for gains, death sentence should be the only punishment. For some time, I was the administrative judge of Muzaffarnagar district. It is the western UP Western district, and there the widowers, soon after they crossed 60, became the icons of their own brothers and nephews. And such brothers and nephews would kill the widower or a single person just to grab their properties. When such types of crimes cannot be tolerated, it is in the interest of the society, and the criminals must be made to suffer the similar way. Friends, these days, the compensatory theory is also being adopted by the courts. Long back, a Bangladeshi woman came in search of an employment to India. She came by train. When she alighted in a town of Odisha, she was abducted by some railway employees and ravished by them. She filed a petition in the Supreme Court, and the Supreme Court had that not only she is entitled to compensation, but also she has a right, though a foreigner, to fundamental right of life and liberty. Friends, she was awarded 10 lakhs of rupees by the Supreme Court as compensation. Then preventive theory. We live in a society led by democracy. The preventive theory says that keep the offenders away from the society, meaning thereby that this kind of preventive theory is comprised of death sentence and incapacitation. Friends, in this, it is said that the juveniles, if eliminated, will not be given a time to reform themselves, to improve themselves, and at a very tender age, they will be put to a barbaric type of sentence. Friends, then what should be the solution? Is a very important question. And it is a fact that one single story of punishment or theory of punishment is not able to tackle the commission of crime. Therefore, the multiple approach theory is being adopted these days. A single theory is certainly not enough. The death sentence should be awarded as an eye opener to those who deal in terrorism, who commit murders, who commit rapes, without thinking about the dignity of human life. A Chicago University conducted a survey and said that 99% cases, in 99% cases, the reduction of the crime is to the extent of 80%. And that's why multiple approach theory is considered to be the most appropriate theory these days. If it is a case of juvenile, then reformative theory should certainly be adopted. If it is a case of hardened criminal, that sentence is the only reply. And also the courts and the jurists, as also the lawyers, must try to find out as to what is the root cause of commission of crimes. And in this context, as prevails the conditions in our society, unemployment, poverty, illiteracy, these are the root causes of commission of crimes. So friends, I say that the multiple approach theory for punishment of the criminals would be most appropriate to be followed in the present times. Thank you very much. God bless you.
Thank you, sir, for your address. We also have another guest for our line, Professor Dr. S. Shanta Kumar, Director of GNLU, but due to a health problem, he could not join us today for the event. Moving forward, I would like to now introduce an initiative of the Delhi Law School, initiative of Delhi Metropolitan Education NIDA, the value-added process. There have been tremendous changes in the education sector in the last couple of years, and considering factors like digitalization, innovation, and industry integration, to work towards continuous enhancement of employability skills as per the industry requirements, the Delhi Metropolitan Education has introduced domain-specific value-added certification courses for its 3 schools of law, media, and management. It aims to create a skill-enhancing environment, bridging the gap between academia and industry requirement to keep pace with the requirements of the corporate world. I feel privileged to mention that under the guidance of Mr. Vipin Sahni Sir, Chairman DME, Mrs. Kiran Sahni Ma'am, Chairperson DME, and the leadership and vision of Vice Chairman Mr. Amal Sahni Sir, and Head Value Added Courses, Mrs. Rishna Sahni Ma'am, and with inputs from Dr. Ravikant Swami, Dr. Rashmi Khurana Nagpal Ma'am, Dean Media School Dr. Ambish Saxena, and Head Management School Dr. Purva Ranjan Ma'am, Value Added Courses Cell DME has made an initiative to enhance the knowledge and skill of students and to make them industry ready by providing courses. I invite Director DME, Professor Dr. Ravikant Swami Sir, to give an introduction to Value Added Courses actually.
Dignitaries present on the stage and luminaries present on the other side of the stage. Students, how many times you have a feeling that the syllabus is not keeping pace with whatever is happening? How many times you have such a feeling? Well, more often than not, we have such a feeling. Okay, and we also feel that like other than the syllabus, we need to know something which is special in our field. We have that feeling. So with this rationale in mind, we thought of introducing value-added courses. The rationale is to provide you something specialized. Of course, for that, we are collaborating with those who are the specialists. And the rationale is to keep up pace with the evolving field of law. Well, we know that we are part of a university system wherein the syllabi changes at a very slow pace. We have a specified period that it will change after 5 years. And I believe 5 years is a very long time. And during that time, the law changes a lot. Say, for example, after COVID, the insurance laws, the mediclaim laws, things have changed so fast. So with these two rationale in our mind, one, to keep pace with whatever is happening in the field of law, and second, to get you something which is of specialized nature, this college has introduced value-added courses. Whatever we have done till now, I would also like to tell you about that. In the management school for BBA, we collaborated with IIT Kanpur. They gave us specialized courses on entrepreneurship. IIT Kanpur is known for its entrepreneurship cell. We collaborated with IIM Kolkata, and they trained our students. They provided joint certifications, and that is how we introduced value-added courses in the management school. Talking about the media school, I'll come to law in the end. Talking about the media school, we collaborated with the Film and Television Institute of India. We collaborated with Vigyan Prasad, and they gave us something which our syllabus was not covering. As far as law is concerned, there are so many areas which are not part of your syllabus, and you need to know them because they provide employability. So we collaborated with Gujarat National Law University for something called maritime laws, an upcoming area which is nowhere close to your syllabus. Today we have the Vice Chancellor of NLU Shimla. We are in the process of requesting her for a specialized course in collaboration with NLU Shimla. Professor P.S. Jaswal is also here, so we would be also talking with sir to help us collaborate with NLU Patiala or other NLUs for specialized courses. Yesterday, Jassam also visited ILI for such collaboration. We are also talking with the International Society of Law for such collaborations. So with this, we take this opportunity to introduce the value-added courses for the DME Law School. Thank you.
To acquaint the audience with the VAT, I request the IT team to play a brief presentation.
I'm Dr. Rashmi Chawla, convener of PNE Value-Added Courses. The value-added courses are curated to include soft skills, new age tech skills, much needed life skills, domain-specific software skills, research skills, entrepreneurship skills, critical thinking skills to revolutionize the landscape of learning and development at DME for nurturing the young budding leaders of great media and legal.
Under the university curriculum, domain-specific subjects are covered. Value-added courses on issues like environment, technology, communication, etc. help in the holistic advancement of an individual as well as the law.
To work towards continuous enhancement of employability skills, as per industry requirement, TME has introduced a plethora of courses like data analytics, data visualization, Six Sigma, science communication, digital marketing, IPR laws, maritime laws, in collaboration with external knowledge partners of top institutions like AFL of IIM and IIT, NIUs, government bodies like Vigyan Parasat, to name them.
I firmly believe that the value-added courses for the law student would enable them to develop holistic perspective with respect to legal issues and challenges in the environment. It would also facilitate them to develop innovative and creative skills through wide array of courses.
These courses provide the media students an exposure to enhance their knowledge, proficiency, and gain academically rich quality experience. With that, they indulge in life projects, community projects, and workshops. Not only that, they get to learn technical skills, which are a must right now in the industry.
Value-added courses, as the name suggests, add value to the curriculum of it also gives value to them in their resume. Media students need value-added courses not only for their enhancement of my training, but also asking the issues. Value-added courses help them and give them the flexibility to learn and accommodate the training and the social political scenario in their attitude and their experience.
I strongly believe university curriculum coupled with high quality value added builds much needed academic rigor. The innovative new age courses with interdisciplinary approach challenges the young inspiring minds. It explores the novel scholarly pathways and builds academic holistic enthusiasm.
I now invite all the dignitaries on the stage to unveil the brochure and formally launch the value-added courses at TME. We are truly honored that our guests could join us here today. I now invite Honorable Mr. Justice Bhagat Singh, sir, to felicitate Professor Dr. P.S. Jaswal, sir, with a token of our appreciation and to confer on sir the citation for his contribution to the field of legal education with a tremendous legacy of over 40 years.
सर पुनः इधर देखना सर
I invite Honorable Chairperson Ma'am Mrs. Kiran Sani Ma'am to felicitate Professor Dr. Nisha Jaswal Ma'am and to confer on her the citation for her academic excellence by being a distinguished scholar and for her contribution to the development of the landscape of legal education in the country. I now invite our Honorable Vice Chairman, Sir, Mr. Aman Sani, to felicitate Mr. Pavel A. Kalashnik and to confer on him the citation for his commitment and contribution to the international relations at the field of law. I request before we conclude the ceremony and move on with the vote of thanks, I request Dr. Jaswal to formally declare the conference open.
It gives me immense pleasure to declare the conference open, and I wish all the participants all the best.
This, we move to the end of the ceremony. I invite Professor Dr. Rashmi K. Nagpal, currently the Additional Director at DME and Dean Law School. She has a teaching experience of over 20 years. Ma'am has been the recipient of the Jawaharlal Nehru Scholarship under the Government of India Scholarship Scheme and was recommended for the coveted British Chevening Scholarship. I invite ma'am to give the vote of thanks for the reason.
Very good afternoon to one and all present at this honest gathering. It's my pleasure and indeed an honor on behalf of DME Law School to hold this vote of thanks. But before that, let me apprise you of the fact that the reason behind choosing the topic of today as the topic of our today's international, why it is international one, is that criminology concerns each one, despite the boundaries of jurisdictions. Our behavior reflects so many things when a crime is committed. So criminology, like Professor Jaswal said, not his field, not my field. When I studied in 90s in the Department of Law at Punjab University, Chandigarh, I never heard about what is criminology. But later on, we could hear was that a course in Master of Arts in Criminology started. But it came to me just by accident that I was invited to take a lecture on criminology during COVID times. And therein I read the story of Valmiki, who was a Nakar as a robber. And he became the author of Ramayana and became the Lord Valmiki. Now, this transition has now referred that nobody is born criminal. We are humans first. What triggers criminality in us, there has to be a reason. And the reason, as the president has come to thereafter, the examination shall be conducted, and on the final day, the student shall be participated in the certificate. So this is the 360-degree program of learning. We are not housed here only, but for learning, we travel to various places. That is our intent to introduce these courses. And shortly, we are grateful to MAM for extending all support. Work with us in collaboration with the expertise of their Center on Geographical Indications, that they should also be providing such an opportunity to our students and reservists. Proposing a vote of thanks is that all our achievements are by the grace of Almighty, and well wishes and good wishes from our well wishers and elders. This idea of conception of this program execution could only be possible by the support of many physicists. When I talk about Professor Jaswal and Madam Jaswal, let me go back to Adi Shankaracharya and a shloka pertaining to the importance of Guru is Guru Brahma, Guru Vishnu, Guru Devo Maheshwara, Guru Shakshat Parabrahma, some say Guru Veda. And then Aristotle remarked that we are grateful to the ones who have given us birth, but for living well, we are even more grateful to the ones who have the tools that taught us. And then, coming about our offering, is Justice Krishna Iyer, in one of his books, Unspeakable Anecdotes, wrote that I have always treated my teacher as a god. I remember the times when I was taught by Professor Jaswal in Law Department, Chandigarh, in the year 90s, that nobody could even whisper in that 1.5-hour lecture. And nobody could dare enter. One sir used to be in the class. And nobody at the same time wanted to miss the lecture, because that imprint of those lectures are still there in each one of our minds, those who were part of that batch. We were fortunate to have been taught by Ma'am and Sir. And there was no question of taking liberty with Sir at all. But the student-teacher relationship has come a long way. My first teaching assignment for 1 year was at Punjab University, Chandigarh, my first job. Wherein from a student, I was like a colleague. And the liberty to now is that I can call up Ma'am and Sir at 10 in the night to seek some advice, some favor, or to invite at any of their occasions. And despite their busy schedules, it is never a no. I think all of us need to develop that kind of a relationship of Guru and Shishya today. We are old type students, I believe, but the legacy can still go on. That relationship has to be of respect, honor, and at the same time, a relationship where we treat our teacher, our Guru, as a parent, mentor, and guide. We are extremely thankful on behalf of the Sunshine Educational Society, on behalf of Delhi Metropolitan Education, we're extremely thankful, honored to have Professor Jaswal and Madam Rishta Jaswal with us today, and providing us with the great insights into the story of Lord Buddha, restorative justice concept, and how we control our desires within the limits of the family. This will, in a way, control our behavior, as remarked by Professor Jaswal. This lecture of Sir and Ma'am should leave an imprint on the mind, as we used to have all the lectures still in the mind when we were taught. I'm extremely grateful and thankful to Mr. Howard for joining us today. Thank you, sir. On behalf of representative of Ministry of from the Embassy, representative of Ministry of Russia, so with us today. He's lawyer by profession, so that is why he took a keen interest in joining this session. Due to weather in town, she could not join us today at the last moment, but she nominated the Deputy Commissioner of Police, Mr. Harish Chandra, to be with us. And his was an extempore, but a worth remembering small session. He could deliver what are the practical insights of the behavior. So we are very grateful to him. At the same time, none of our endeavor can be executed without guidance of Honorable Justice Power Singh. But there is a mental guide in all our endeavors. Equally grateful to Mr. Sani, Chairman, Educational Such and Educational Society. Mrs. Kiran Sani for sparing time. She has a very, very busy schedule. Upon our request, she joined us today morning. Mr. Aman Sani is the guide, is the leader here in the campus to show us what innovations can be made. Mrs. Nishta Sani, we are extremely thankful to her for introducing these value-added courses to be the chief coordinator for the courses. With her vision and endeavor, we are able to execute a lot of management studies, media education. We are able to achieve a lot of it. I'm equally grateful to Professor Swami, Director GME, for all his help and his leadership, and he takes no time to approve anything sent to him. By faculty weeks, the students in the organizing team deserve mention, because what seemingly is this has a hard work and labor of approximately 4 months. So applaud yourself. Those in the AC team been here, I find them, they don't go home till 6 o'clock. So I need all of you to applaud for yourself. And then lastly, ma'am talked about justice, peace, because it just one said about peace. Ma'am talked about the health of humanity with a beautiful recitation. And carrying on that only further, is Poti Parvar Jatwa, Pandit Bhairava Koe. Dhai Akshar Prem Ka, Ganesh Pandit Koe. This Dhai Akshar Prem Ka is not the physical love. It is a love for humanity. And once that love is there, I think many of these things, many of our behavior can be overcome. Thank you so much for being present here, being wonderful listeners here, being wonderful audience, and thank you all.
But,